Clarence Thomas, Supreme Court judge, writing for the Supreme Court, he says, first of all, I'm joining Judge Alito. This case involves a death penalty case. I agree that Ruben Gutierrez lacks standing to bring a federal lawsuit alleging that Texas and their post-DNA rules violate due process. Okay, so Ruben sues someone in Texas who is denying him the right to test some DNA evidence. Texas says you have no right to test that DNA evidence. He says you're violating my due process. He writes separately to emphasize, though, says Clarence Thomas, that this court has no business intervening in this case in the first place, writing the Constitution does not require any state, Texas or any of them, to establish procedures for state prisoners to challenge the validity of their convictions after the trial. Now, his suit rests on non-existent liberty interest. The Due Process Clause protects people from government interference. It does not guarantee an entitlement to government benefits like Texas's voluntarily adopted post-conviction procedures. In other words, you're not entitled to that outcome. By intervening to revive this suit, this court facilitates this unjustified delay, and that is why I, Clarence Thomas, respectfully dissent. And so, Clarence Thomas not happy about this. I thought this was a very instructive dissent here on due process and how the majority of the court is saying he can sue. He should be able to file a claim to go get that DNA evidence if he wants to before the death penalty is executed. And ultimately, I think this is a political decision.